After the landmark triple talaq judgment, now the Supreme Court has paved the way for faster divorces under the Hindu Marriage Act.
Apex Court has shown the way forward perhaps when it has gone ahead and waived off this mandatory waiting period of 6 months for divorce by mutual consent, because the Supreme Court is of the opinion that there is no point in perpetuating a purposeless marriage, and it only goes on to enhance a couple's agony.
The 6-month cooling period under the Hindu Marriage Act has been waived off for those couples who are already separated and are filing for an amicable divorce. Women and activists across India have welcomed the move.
मैं सोचती हूँ माननीय सुप्रीम कोर्ट ने जो कहा है वो बिल्कुल ठीक है कि जब डिवोर्स होना ही है तो उसमें इतना लंबा प्रोसीजर क्यों हो.
Already we know it is all time consuming. Since now this ruling has come, I think it will benefit the people.
But several other activists believe that doing away with the cooling off period will lead to more impulsive divorces, leaving no room for reconciliation.
Our cases wherein a couple, they finally, even after the first hearing, they sometimes come back together. And here, if you don't give that room of 6 months for them to at least decide for themselves whether they actually want a divorce or they would like to come back together, then I think it's not a very positive, rosy picture.
I think 1 year would be better, because 6 months is very less time for the couples also to think what's exactly the problem.
With this path-breaking judgment, we ask, is India headed towards faster and less complicated modern divorce laws, or will this result in more impulsive divorces? Mirror Now report.
Good evening, you're watching The Urban Debate. I'm Faye D'Souza. Thank you for joining us on this evening. It's a very interesting order that's come out from the Supreme Court now that shortens the waiting period. Remember, this has some conditions to it. It's not a blanket shortening. It doesn't mean that couples can just decide to get divorced, file for a divorce and get that divorce immediately. You have to satisfy some conditions, including being separated for at least a year, and a list of other conditions that the Supreme Court has put out. But the question we're asking this evening is this: does this empower couples who want to go separate ways to begin their lives as quickly as possible? Or will it encourage what now activists are calling impulsive divorces? Our phone lines are open to you. I'm interested to know what you think, as well as invol.in, where you can log on and leave us a comment or a question that will automatically pop up on our screen. But joining us on the show this evening, Geeta Luthra, Supreme Court lawyer, will join us through the course of the conversation. Shamina Shafiq is a former member of the National Commission for Women. Brinda Adige is a women's rights activist. Shahryar Khan is a social thinker and an Islamic scholar. Mrinalini Deshmukh is a senior lawyer who specializes in family court. Rahul Ishwar is an author and an activist, and Pandit Ajay Gautam is a founder of HumHindu.com. Remember, I also want to remind you that this order that's come out from the Supreme Court specifically applies to the Hindu Marriage Act. I'm going to go one by one to each of our panelists to understand where each of them stand and what they think. I'll start with Shamina. Shamina Shafiq, you did speak to our reporter earlier today and you said you don't believe this is a good thing because it will encourage perhaps some impulse and it doesn't give couples enough time to reconcile, if that's possible. Explain to us what your stand is.
Yeah, that's right. Yeah, that's very true. Actually, you see, whenever a couple decides to file a divorce on mutual consent, obviously, I mean, they first consult a lawyer, and as far as that period of 1 year that you spoke about, that, I mean, the couple has to be separated for 1 year to sort of apply and even go for a mutual consent divorce. Well, honestly, I mean, there's so much of manipulation outside the code that this so-called separation period is manipulated once, I mean, the couple decides that we want a mutual consent divorce. And if there is no cooling period, the 6 months period could have been shortened to maybe a month's period. But I believe that it is very important to have a cooling period, because it's not just about a man or a woman. It's also about sometimes the family, the children who are involved into it. And such impulsive decisions sometimes, which suddenly the couple feel, you know, let's just find our way apart. It actually kills the entire system, the basic system of the family unit. And remember, even triple talaq that we were fighting for in one sitting was the same thing, that you can't have an impulsive divorce. You need to have that cooling period wherein there is a scope and room for reconciliation. And if at all a couple decides to get themselves divorced, I think wait for a month or maybe 2 months or even 6 months is not a too long a wait. But yes, it certainly leaves some scope, some room for them to rethink about their decision, maybe in terms of their children, maybe in terms of their life ahead or whatever it is. So I think it is very, very important.
All right, fair enough. But I also want to point out that with a 1-year separation already done, which means that the courts have put out certain clauses saying you have to have already been separated for a year. You have to have figured out your alimony, your child support. You should be in agreement about that. You should, and this is the very interesting part, and I'm sure there's going to be a lot of conversation about this. The court has said that you can use a medium of video conferencing. So both parties don't have to physically appear in court. It also permits genuine representation from close relations like parents and siblings to represent someone. Mrinalini Deshmukh, I'm going to come to you with this. There are two arguments here. One is, of course, if a couple is going to be separated for an entire year, one assumes that they know what they're doing, and if they've mutually agreed on all of the things that the court has put down, then Mrinalini, that they're sure. Do you think that this removes chances of reconciliation?
No. In fact, I would react by saying that it's a very, very positive, constructive, and I would say a very welcome relief to a lot of couples who are there. And a person like me who works with these matters probably daily, I can see what the agony the people go through. So let's understand what this petition is all about. Rather, this judgment is all about. It talks about a divorce by mutual consent. As the law exists today, there is a 1-year separation, and which is a minimum requirement, 1 year from the date of the marriage, and post the filing of the petition, minimum waiting period is 6 months, maximum is 18 months. Okay. What does this judgment do? The judgment is not touching upon any of those things which are there in the statute. The judgment says that Section 13B of the Hindu Marriage Act, Clause 2, which says that the minimum waiting period should be 6 months, could be as a directory measure, and it is not a mandatory measure, is what the courts have said, which means that there is a scope for the courts, and that discretion is given to the courts to decide whether should you really keep those people hanging in a situation, yes, which is so full of pain and agony, or could we as a court give relief to them. Now, if you see the judgment which is there, the courts have also spelled out, it's not a hurriedly drafted order which has been given that no, it is just directory. In fact, if you would permit me to say, in para 13 of the order, the court says that the courts will consider, the trial court, the court which is considering how long the parties have been married, how long is the litigation pending if there is any, how long have they been staying apart, are there any other proceedings, have they attended the parties' mediation and conciliation, have the parties arrived at genuine settlement, and so on and so forth. So I think the Supreme Court has considered all these factors. So I would with utmost respect sort of disagree with the co-panelist who has just said that it is hurriedly getting into divorces which are there. Finally, the discretion is given on the trial court. I may just take 30 seconds more, Faye, so that I'll complete my thought process. And please bear in mind that in some genuine cases where such things are there, even the courts feel that this 6 months is a long period, but they are bound by the statute. Today, the Supreme Court judgment has given a discretion to the lower courts to consider waiving of 6 months period if the court is satisfied. It's not only the litigants. If the court is satisfied that these are the conditions that have been fulfilled and there's no point in prolonging the agony. Right. So I think you have to look at it from this constructive way rather than saying it that somebody is coming here to sort of, destroy the institution of family or the divorces are going to be so easily given. I don't think that's what the intent is.
So we do have some conservatives who believe that. Rahul Ishwar joins us right now. Rahul Ishwar, I understand, my team tells me that you believe that this is bad for marriage as an institution and society in general. Explain to us why.
There are two things. One, what we really need to save marriages and save the institution of family is something like premarital education or marriage preparation course. In states like Colorado and United States of America, you need to have a mandatory marriage preparation course before going to marriage. Those are the progressive steps, the real progressive steps you have to take. Today's decision by Supreme Court is unfortunate because marriage is an institution, especially Indian beliefs, that has some kind of sanctity. And any impulsive decision that can be there can really cost marriage and broken marriages and these kind of loosening of the whole structure of marriage is ill for the society. Third point, and more importantly, if they are having a cooling off introspection period of 6 months, it is good. That's the reason why it was there from earlier on. And we cannot treat marriage like love affairs where you break up and move on. Marriage is a much more serious affair, a serious commitment. It's a social commitment. Two families are getting together. So I believe that kind of 6 months period is a well-balanced period where they can have a time for introspection. We need to save the idea and institution of marriage and family because they are the basic units of the society.
Rahul, even the courts are considering the fact that marriage institution is here for the keeps and we must preserve the institution of marriage.
Exactly.
We are talking about these exceptional cases where parties go to a court. There is a long pending either litigation or disputes which are going on. They finally come to it and again the courts ask them because the statute says wait for 6 months to wait. It is in these extreme cases. Nobody is saying that please encourage divorce. Nobody is saying that destroy the family or the institution of marriage.
Yes.
We all have greatest reverence for that. But in these exceptional cases, the courts have carved out these things. And I think we should respect the wisdom and the experience of the courts where they have seen these cases much more than probably you and me as,
But please remember, ma'am, nobody disrespects court. We have the highest regard for the court.
I appreciate.
But unfortunately, when we take a position, that position should be for the protection. I wouldn't use the word conservative, but preservation of the society, preservation of value system. And that's the reason why even Europe...
How is it destroyed by this judgment? How is it destroyed, Rahul? Rahul, I appreciate what you're saying. We all subscribe to that view, that the institution of family, but how does it destroy? I don't think this judgment destroys those values, if that's what you're intending.
Of marriage.
No, but Rahul Ishwar, the Supreme Court has said it will only prolong agony. So how are keeping two unhappy people together for an additional 6 months preserving the institution of marriage?
Absolutely. Marriages for certain reasons. People are unhappy in marriages for certain reasons. Those reasons needs to be addressed. It is not a mere plank of individual choice. We always say...
But that's what the judgment says. I just read out to you so that I don't make any error.
The mutual consent. Please understand the phrase mutual consent.
See, please remember, consent is a very tricky word. We are not against consent.
But that's the courts are there to see if there is any force or coercion. Please, Rahul, we see it every day.
Ma'am, beyond consent. So I'm pointing out to a paradigm that is beyond consent. Of course, consent is very important. But beyond consent, men are from Mars and women are from Venus. We always, teach in popular psychology.
That's really something you should not teach people, really.
But please remember, marriage as an institution needs to be saved. We believe Saat Janam ka hai. I'm not subscribing to Yash Chopra kind of love. But having said that, some kind of deeper commitment to the institution of marriage and family system should definitely be there. Even right now, people in West are having a resort.
Right. Okay, all right. Let me bring in the other members of my panel who haven't spoken yet, and I just want to put this out there. I believe that consent lies at the very heart of marriage. And if you have mutual consent, that these two people want to go their separate ways, then these two people know best. So to say that there's much more beyond consent, I don't see anything beyond consent. I believe that consent should be at the very basis of how we live as a society. And the moment you take away that consent and force two people to live together unhappily, then we're perhaps breaking that down. Let me bring in Geeta Luthra, who joins us right now. If Geeta can hear us. Ms. Luthra, thank you for joining us. What is your response to the Supreme Court judgment waiving off the 6-month wait on divorces?
So I think it's very welcome. When the law was enacted in 1976, perhaps that might have been in the order of the day that you should wait for 6 months. There is a cooling period because that time divorces were far and few between. Now with the change in society, you have a huge incidence of divorces in the metropolis and in the cities. I think it's almost as high as 17%. Now, if you're having such a high rate of divorces, I think what we've experienced is that between the first and second motion, one or the other spouse may sometimes become spiteful or revengeful, or angry or wanting to get out of what they have agreed to. Now, I don't think that should be permitted, and if we want to avoid that, then you have to reduce the cooling period or take off that cooling period, so that if you think enough, think well, take advantage of a situation, maybe it's custody of children, maybe it's getting your husband or wife out of the house, maybe it's getting a property, maybe it's getting some jewelry, whatever, you take advantage or refusing to give something for the lure of a mutual consent, and then suddenly you backtrack. You may backtrack, but the fact is you are leading the other person to 3 or 4 or 5 years of litigation, when it was for the sake of mutual consent that they may have given up many of their rights. So you can't make a person agree to something, acquiesce in something, and thereafter try and resile from it.
Geeta, I beg to differ with you, because this judgment is not talking about withdrawing the consent. I think that the law still permits that if one of the parties wants to withdraw the consent for genuine reasons and there is justifiable reason, I don't think this judgment is dealing with that. This judgment is merely dealing whether Section 13B Clause 2 is mandatory or directory. This judgment is saying, let us make it directory, let the trial court get into and see if all the conditions are complied, as has been mentioned here. And if it is so, then do not prolong the agony. I think the option of withdrawing the consent is still built in the section.
Let me bring in Pandit Ajay Gautam of humhindu.com. Pandit Ajay Gautam,
so I don't think I made myself clear then.
Right, so if I understood Geeta Luthra correctly, she said people
withdrawing consent.
Yes.
It is about, yeah.
Geeta Luthra basically said that if you reduce this 6-month waiting period,
it's about taking advantage of a situation.
That if fewer people, you reduce the opportunities to take advantage of someone by promising them consent and then withdrawing it because you got what you wanted while through your negotiations. Pandit Ajay Gautam of humhindu.com. This specifically applies to the Hindu Marriage Act. As a conservative yourself, do you believe, like Rahul Ishwar, that it stands against society?
On a one hand, the Honorable Supreme Court abolished triple talaq in a one sitting and awarded minimum 3 months to dissolve the marriage according to the Shariat. And now the Supreme Court said that there is no time limits there, and the minimum 6 months which has granted under the Act of Hindu Marriage Act 1995, it may not require to consider if there is a mutual consent, you will take the divorce within a while. When we perform our religious ceremonies in connection with the marriages, there is a mantra of Shukla Yajurveda which is according to Tubhyam agre prahevant surya vehetu na saha punah patibhayo jayam dagne parjaya saha. That means that the marriage is not a contract, this is an oath, and the couple taking oath on the name of God, on the name of Agni, on the name of society, ki we will continue our marriages, and if any kind of problems and any kind of hurdles we will face in our marital life, we will try our best to sort it out, and we will try to union it. So there is a oath. This is not a contract according to the Hindu Marriage Act. And how can you justify that on a one hand you allotted 3 months time to the Muslim community to ban the triple talaq in a one sitting, and now you are wiping the minimum 6 month time, which is a chance to reunion of the couple they are facing some trouble in their marital life. So I am not happy with this kind of judgment, and the Supreme Court may consider this judgment over the issues which we are raising, because the marriage is an oath in according.
But to be fair, Pandit Ajay Gautam, if we consider marriage an oath, then divorce should not be possible at all.
Absolutely.
if you consider marriage an oath, then divorce should not be possible at all. I want to bring in Shahryar Khan and Brinda Adige. Shahryar Khan, Pandit Ajay Gautam brought up the triple talaq judgment, which, to be fair, in 3 different places in that judgment talks about the attempt at reconciliation. I just want to point out to our audience one more time that this doesn't mean you get an instant divorce. The 6-month waiver means you have to have been separated for at least a year before you applied. And the court should be convinced that there's no room for reconciliation. Shahryar Khan, and Shamina Shafiq, I see you. I'll come to you. Shahryar Khan, go ahead.
Faye, this is a very progressive and a pragmatic observation order from the court. I welcome this decision. If it is oath or anything else, it's a question of both. There are 2 people involved in an institution called marriage. Where is the sanctity if they want to get rid of each other? And why should they suffer in the misery of a so-called institution? No matter what you call it, if 2 people don't want to live in an institution or an arrangement, traditional or contractual, it is better to get out of it. And the Supreme Court has said that there is a cooling period of 6 months, subject to all settlements and obligations and everything. There's still arbitration. If the 2 people don't want to live in that marriage, it is better to get out of it. I think it's a very, very progressive judgment to have come from the Supreme Court. But this is not the first time. In 2012, such a similar decision has come from the Supreme Court of Justice Altamas. So this is a reiteration of that, the judgment that has happened in 2012. So I welcome it. Even triple talaq also, I have condemned triple talaq, and this is after triple talaq, after banning and annulling triple talaq. This is one of the finest judgments to have come from the Supreme Court. I welcome it.
Brinda Adige?
You are thinking, Mr. Khan, you are thinking about the happiness of the parties who are filing their petition before the court to dissolve their marriages. But what about the children who may suffer a lot after the dissolution of marriage? After the talaq.
No, I told you, sir. I told you after the settlement, sir. Pandit Saab, I said after the settlement of issues, after settling the issues of children, of property, jewelry, even if the couple don't want to live with each other, and then they have to go. They're entitled to their freedom. You can't suffer in perpetual misery in a purposeless marriage.
Purpose of marriage is, I understand what you want to say, but my core question is that you are thinking if the parties is not appeased, the circumstances change in every day, and there is what is the possibilities on the floor within the period of 6 months.
Sir, for that the court has given time. It is not. No, sir. The divorce is not preemptory.
Okay. 1 second, gentlemen. Brinda Adige has not spoken yet.
Let me.
Brinda Adige, please go ahead.
You misunderstood me.
Whether it is a matter of triple talaq or the matter of mutual consent.
It is consensual.
All right, Brinda Adige, please. Brinda Adige,
all conditions.
Yes, whether it is a matter of triple talaq or the matter of mutual consent, let us accept that the court has paved way and actually made the space much wider in the issue with regard to women's rights and empowerment. This is something we need to accept and look at. Now, what the 2 other gentlemen are arguing about is this institution of marriage. The 2 people who get into this marriage as an institution, whatever they consider it, they do consider it a sacred union. They also look at it as one of the most happiest day in their lives. Now, every divorce is having a separate, different characteristics. All are not same. If 2 people have decided that they are unable to live together, and as the court has pointed out, there are those stipulated mandatory periods of time. After that, if they have asked for divorce, in the name of children, should a person in that marriage suffer? Because then the family suffers, the entire institution of the sacred sanctity of marriage suffers. So what are we trying to uphold in this institution that, we are breaking families? Because this is what has been told for ages and has subdued and oppressed women. We've continued to say these things because all the sacrifices, everything that has to be let gone is only by this woman. It is by the wife. Whether it is my religion, it is my culture or my tradition, it expects the wife to forego, sacrifice in the name of holding on to that marriage. Now that is what is being argued and discussed and challenged.
Right, and you know, my question here is why limit this only to the Hindu Marriage Act? What about the Special Marriage Act? What about the other marriages? Yeah, it will possibly be incorporated.
Marriage as an institution has sanctity as long as people want it to be, sacred.
All right, one at a time. Our phone lines are also ringing. We're going to start bringing in callers right now, but rebuts. Shamina Shafiq has waited for a while. Shamina Shafiq still believes that this is a bad thing. Shamina, go ahead.
And you are wiping the all possibility of the reunion of the
my two female panelists, the reasons, especially Ms. Luthra, the reasons that she has given are exactly the same reasons why I say that there has to be a cooling period. One, and I'll give you an example to justify that. See, there is a vast difference in the kind of complexities the society has as far as India is concerned. We have some people, please, allow me to speak. I did not intervene whenever all of you were speaking.
Go ahead, Shamina.
A couple living in Delhi or Mumbai or maybe a metro or maybe Lucknow, it has a different kind of a sensibility and understanding of the institution of marriage and the laws that are there. But when you go to smaller towns, there are women who are at the receiving end. I give you one very small example. A woman I personally know, young girl, 25-year-old, and she was made to go back to her Maika because the husband was working in BSF, and she was told, no, the husband is not living, he's on his duty, so why don't you just go back home and you can come when he comes. And then that period was manipulated as a cooling period of 1 year, or rather the waiting period, separation period of 1 year.
But then there's no consent,
and then she was forced to file in for a mutual consent.
We are talking about a consent.
Otherwise there were pressures on her. And there are n number of cases such. Besides, now I'll talk about the consent that you're talking about. See, obviously if there two people decide they do not want to stay in a marriage, I think so far so good, they should separate. But why are you, and besides the argument which are being given, for alimony, then there are discussions, there are certain, as if the woman is the culprit. Woman is not the culprit. She is as it is in the receiving end. Even after the alimony or the monthly amount which is fixed by the Honorable Court is mostly not given to women, and my lawyer friends would agree to that. Although I don't think so they'll be able to agree it on channel, but the fact of the matter remains that the 1 year separation period is also manipulated most of the times, or rather sometimes, and also the woman is not the culprit here. Why are you making the woman as if for 6 months she will be able to manipulate her alimony and she will be forcing for her in-laws to do certain things, otherwise she'll quit? No, it's not like that. It's the other way around. Another very important thing that you need to understand is that when two people are deciding to call it off, then obviously they've been through a lot of situations. So 3 months or 6 months is at least a minimal time wherein they can maybe think about their future life, especially the woman. You cannot ask a woman to just walk out of a marriage because there are certain pressures which are on her.
But if there is no consent from the woman, this will not take place. Please appreciate.
No, but there is no consent from a woman. Respond to what Shamina said. She made a very good point.
Consent is forced on her.
She's saying, what if it's manipulated consent? What if the agreements are not adhered to?
Where is the consent?
Please understand one thing.
And I have gone through so many cases as NCW member.
Shamina, may I
quote those cases to you.
Shamina, may I just answer your question?
What happens if the consent is manipulated?
About the consent being manipulated.
Yeah.
Now, when you're talking about the consent being manipulated, one of the clauses in a consent petition is that the consent has been obtained voluntarily without coercion, fraud, etc., etc. It is the duty cast upon the court at the time of passing the final order to ascertain and be satisfied. Please understand, Section 13B uses the word the court has to be satisfied. It doesn't mean that you file a mutual consent petition, you have to do it. It is the inquiry done by the court. If the court even feels, even for a moment, that there is some manipulation or there's some force or coercion, they say, please go back. I'll keep the matter pending, come after 4 weeks and do it. So let's not say these things. The courts are doing their job exceedingly well in ascertaining the consent of the parties. So there is no manipulation even if it is there at the outset.
Okay, so this is very interesting.
Smart women, there are women who are vulnerable.
Okay, so this is very interesting because there are two arguments here.
And
on one hand,
also, with due respect to the Honourable Court,
what is your point?
I just want to quickly say one point. With due respect to the Honourable Court, there is a huge pendency in the court, and that is why otherwise
how does it matter if the 6 months is reduced? The pendency will remain the same.
That period, why don't you, just because the court is burdened with cases doesn't mean that you will make the woman suffer.
But who's saying the woman is suffering? Why is there there a presumption that in such cases the woman is suffering? Nobody would even allow the woman to suffer for a minute. It is when the parties willingly request the court that, your lordships, this is what has happened. We are unable to live together. We've taken care of everything, children's custody, alimony, etc., etc.
Right.
Friends and everybody has helped us out. Please grant us that relief and don't keep us in this prolonged agony for 6 months. No woman suffers, no man suffers.
No, but let's also bring in, I also want to bring in Geeta Luthra here, manipulated consent and understandings that are not adhered to in terms of alimony, in terms of support and child support. You also mentioned the fact that there is manipulation of consent one way or the other. Do you believe, like Shamina Shafiq is saying, shortening the period down to less than 6 months will actually be disadvantageous to women? Because on this panel right now, women's rights activists are disagreeing.
I agree with women rights panelists. See, there is always the scope of manipulation and misuse. Sometimes by the woman's side, she can be powerful, she can have powerful family. They may force or rather bring pressure through filing false cases or something, agree to a mutual, otherwise, we'll do this. So either way, either party may be vulnerable if the consent is brought about by circumstances which are beyond their control. But that's there in every situation of consent. It will be there 6 months later. So the first aspect which was said by one of the speakers is Hindu marriages are sacred. I agree with them that Hindu marriages are sacred. This is only where both parties mutually agree that the marriage is no longer a tie in which they want to remain, and they are more miserable within the marriage than outside it, that they decide mutually to separate. Now, what is the Supreme Court judgment doing? It's only saying, let there be a first motion, and if both parties agree, then they can move an application to the family court saying, kindly dispense with our 6-month period, make it shorter, reduce it to 7 days or virtually nothing, and it's for the family court then to reduce it. The reason it is, they've come with the interpretation this is directory and not mandatory. Now, many years ago, there are several mutual consents which even I have got done, which are cases where first and second motion, the 6 months was condoned. This was standard practice. We did it in Supreme Court under Article 142. We did it in the High Courts. We did it in family courts till that Jain versus Maya Jain judgment came. It was Justice Kabir's bench which was condoning, saying we can do it under 142. And then when this Jain judgment came, the court said, no, we don't think, since this is a condition brought by Parliament, we don't think it should be reduced. And we went back to a period when when it was considered mandatory. Now the question is only this, not that you are not breaking the marriage is breaking up anyway. The question is, can you reduce their agony of 6 months separation where either side may manipulate?
Yes.
And or change their mind in order to extract something more or refuse. For example, you say, I will give you visitation or custody to the child in the second motion. And you keep delaying it and then not going for the second motion.
Not the man. So that means you want to say that it is the women who are extracting money out of their husbands.
I'm sorry, 1 minute. One minute. I think don't speak out of turn. I am not saying women are extracting. I'm not saying men are extracting. Either party, we are all human beings. Everyone can manipulate. So one or the other, which may be able to have an advantage, Maybe the husband is extracting, maybe the wife is extracting. It can happen.
Right.
But 6 months is not required if the parties jointly decide they don't want the 6 months. If they don't decide on that, then the 6 months will remain. So I don't see how it is harmful.
Right. Amandeep, right. Amandeep is on the phone line from Shimla.
Divorces were few.
Right. Amandeep, on the phone line from Shimla. Go ahead.
Good evening, ma'am. First of all, thank you so much for speaking on this topic. Actually, it's really, I'm on the same situation since last 2 years. Me and my husband filed mutual divorce last year. But after 6 months, he changed up his mind and like, hello?
Yes, go ahead. We can hear you.
And he changed up his mind. So it's not like, what I want to say is that I'm for this notion that divorce cooling period is given off, because there is so much of humiliation not on the husband and wife side. It's humiliation on the family side too, because there's so much of harassment, and otherwise also we have to prove so much for the domestic violence case, for the other cases as well. So this is really, I'm for this notion that it's really good to get divorced in a week's time. So it's just wasted because of mutual consent. We have come to this situation, and where we no longer can stay with each other.
All right. Really, so this is interesting. I just want to point out that this does not mean that you can get divorced in a week's time. You have to have been separated for at least a year, and the court needs to be satisfied that there's no room for reconciliation. Pandit Ajay Gautam, go ahead. Ajay Gautam, go ahead.
Ever they check the statical details in respect of the petition of divorce which has been withdrawn during the cooling period? Have they gone through these kind of data ever?
Well, there have been previous cases that the Supreme Court has referred to in its order.
70% divorce petition has been withdrawn during the cooling period. The statical data on the session courts available on the floor.
That's not true.
And this is my main concern, ki when the circumstances has been changed, so then might be there is so much scope and possibilities to save this marriage institution apart, ki we will go and make a faster way to dissolve the marriages. This is the talaq, divorce is a stigma on the society, and every responsible person make its effort to save this institution. A part of that, ki we will show our eagerness to dissolve these marriages.
Sir, the courts will also make efforts. It is only that if the parties are willing and they want it when this provision comes in.
Right.
Sorry.
Go ahead, Shariar Khan, go ahead.
I don't agree with the gentleman. I don't agree with the gentleman. I think to put it straight, it's a blatant lie. 70% withdrawal in a petition is something which is unheard of. If the mutual consent itself means that everything is settled about the children, about the jewelry, about the property, only then people come on board and, then decide to part ways. And this 70% is, I don't think, it's very specious and
file an RTI application and get the data.
The court has clearly stated, mutual. Sir, wait, sir. No, I subject, sir, if you're right, it's okay, I stand corrected. But, what I have seen, what I have seen in the Muslim, divorces, and there is hardly a withdrawal. Even if there is a withdrawal, there is a compulsion, coercion on either of the parties. The man could be coerced and intimated by 498A, which a woman may threaten to file a case against him in the police courts, or a woman because of her inherent vulnerability. These things happen. But in the courts is mutual consent, then that means there is consensus. There is concurrence of families and the parties involved. In such a situation, this decision from the Supreme Court is welcome, very, very progressive and pragmatic for both the parties who live in a miserable thing called as institution. Yes. So there can't be an institution when the people involved in it don't want to be in it. That is the main thing.
Right.
That's a very basic thing.
And I just want to point this out. So the fundamental argument here is the one group of women activists who believe this is good for women. There's one group of women activists who believe it's bad for women. And then we have the two conservatives who believe that it's bad for society in general. Geeta Luthra, respond to what Mr. Gautam said about the fact that 70% of the divorce petitions get pulled back during the cooling off period. Is that true?
No, I think it would be about a 5 to 10% which happens. It's not much more than that. In fact, even today I would have received several calls saying, isn't this great? Isn't this great? So this is a misnomer, and I think it's equally good for women and men. A number of times you come across women saying, we are filing all these cases so that our husband agrees to a quick mutual consent. So we are filing these extraneous cases because we want a quick mutual consent. So there will be circumstances where equally, it's not a time when women don't want a divorce. So equally, there will be almost an equal number of women as an equal number of men who want the marriage to be over for reasons of whatever reasons of their own that are there. So to say that it will work hardship on women is absolutely incorrect. I think it's a succour both for men and women, and the option is always there. You don't want a mutual consent, don't go for it. And the courts will normally send you to a counselor. The courts have a duty to find out, are you happy with it? Are you okay with it? Is the girl well taken care of? Are the children taken care of? Obviously, with the amount of time load on the courts, they are not able to get into the depth of every case, but they do try and send them for a mandatory counseling session. They do try and make inquiries. If the girl is not taking any maintenance, they find out if she's well taken care of. She may not tell the truth, but the fact is, most courts do make an attempt to look whether it is voluntary. And if it isn't voluntary, you always have an option to get it set aside on the ground of fraud. So there is always that option. The fact is, there is a first motion, there is a second motion. All that you are saying, if you are going to get the house, for example, if you're a woman and you're going to get the house in the second motion because the husband's scared that you may resile, he will give it to you within a week instead of giving it to you after 6 months. So there are many positive aspects to it. I don't see any negative aspects.
Right. All right. But we have some views that are coming in from our audience, and it seems yes, it seems like our audience is also split down the middle. Lovish says society is changing and laws should change in tandem. Kiran says sometimes couples take a call in anger.
And Faye also,
yes. If you would just allow me, Kiran says sometimes couples take a call in anger. 6 months ensured that it's a thought-out decision.
Institution of Faye's.
Sharia Khan, just give me 1 second. I just want to read out.
Marriage is not an unequal institution, Faye. There is jungle path. Yeah.
But I just want to read out those responses from our viewers. Shreya says people who think the ease of divorce will affect society are fundamentally misogynistic. Yasmin says a mutual divorce should be as fast as possible in order to allow people to move on. And there's an anonymous, a response that says, I agree with Shamina and I disagree with Miss Deshmukh. We also have an anonymous caller on the phone line who doesn't want us to reveal her name, but she would like to talk about what she's going through. If you can hear me, go ahead.
Good evening, panel.
Good evening.
Hello?
Yes, we can hear you. Go ahead.
Okay, I am calling in from Mumbai.
Hello.
Hello?
Yes, go ahead.
I am calling in from Mumbai, and I had filed a domestic violence in the year 2014. In the year June 2014, which I did not get any, nothing productive happened.
Okay.
This year, earlier, I withdrew that case.
Okay.
When I filed the divorce, domestic violence,
In turn, my husband filed a divorce case. That is in 2014.
Okay.
We have agreed for mutual consent in last year in June 2016.
Okay.
It's been almost end of 2017, and I do not have any productive. Nothing is happening. I mean, what can I expect from the new law? Secondly, I have a 4.5-year-old daughter. So, what should I expect?
But Mrinalini, it does say, and right, okay, so the last part of this order says very, in a way that it gives people a lot of faith. Parties are now at liberty to move to concerned courts for fresh consideration in the lights of this order. So, for our anonymous viewer, does this change anything for her? Mrinalini?
No, I think what your problem is that probably the terms are not being complied with. So you don't fall under this category. It is only for those couples, I do not know your name, but so I'm just addressing you, that it only applies to those couples who are willingly entered into a mutual consent, who have complied with the terms that they have agreed upon, whether it's alimony, child support, etc., etc. And they're just languishing for this period of 6 months, and they're both keen to go. And that is where the courts say that such cases, not definitely all cases, such cases can approach the court, and today the courts cannot say that this is a mandatory thing. They will now say it's a discretionary thing. And again, I repeat at the cost of repetition, the satisfaction of the courts will be satisfied that there is enough that has gone into all these things, and now both the parties want it. I as a court want to assist the parties to get out of this situation. This is what the judgment is all about, and not other cases otherwise which are there, or in an unfortunate situation which you are also there.
Captain Sher Amir Singh on the
application under section 156(3) CRPC has taken more than 1 year to decide, which the Supreme Court said that this matter should be decided within 7 days on the name of primary inquiry, and the application which filed under section 156(3) CRPC, they are not decided for more than 1 year. So what is going actually on the floor is different, and what the Supreme Court said, it's a different. I am talking about the practicing, and my fellow panelists questioning on my statical details. So I would like to inform you, there is a more than 8,500 application filed in 12 district courts. I have the all complete data. If you want to share, if you want to know, I will share the all statical details about the application of divorce, about the application under section 153, under the complaints of the 192 police station, where the 76,118 police officials
very well, sir.
and posted, sir. So please, I am talking about.
It's very well.
Divorce applications are not filed in police stations.
It's very well, sir. If people are resigning.
Divorce applications are not filed in police stations. They're filed in front of the court.
I'm saying, I'm informing what is going on, what kind of statistical details I have. I am not saying that the application filed in the police station. I am saying that there is a 192
excellent, if you have the statistics details.
Police talkies, and only 59 police stations are under the surveillance of CCTV cameras. I am just saying I am standing at here with complete statical information.
Lot of arbitration, lot of coercion happens in the police stations. Let us take the statistics from the court. Let us take the statistics from the court.
Please do not, please, I am saying, please do not question about the credibility of my statement. What I am saying.
All right, fair enough. I don't want to get derailed by the credibility of this one statement, because it will derail us from the conversation that we're having.
They are very different from the statistics from the courts.
Right, I don't want to get derailed by this conversation about credibility of data. I have Captain Singh on the phone line from Chandigarh, and then I'll come back to my panel. Captain Singh, go ahead.
Hello.
Yes.
Hello.
Yes, go ahead.
Hello.
Yes, we can hear you, Captain Singh. Go ahead if you can hear me.
Madam, I was hearing the debate very keenly.
Yes.
This lady from the National Commission for Women has been harping on one fact that women are being blamed. I am a victim of this. My wife left me in 2007 with a 2-day-old baby.
Okay.
I have been bringing up the baby individually. I have a mother who's 66 years old.
Okay.
I have no track of the lady, where she is, what she is doing, and I don't have a divorce.
Right. You cannot
I'm a
marry
disabled
again.
army officer. Overcoming my disability, I am looking after the girl. And these gentlemen are harping on the institution of marriage. Who wants to live in an institution?
Sir, tell me, in spite of Supreme Court judgment, can Muslim divorce wife by saying talaq thrice in a 1 week and claim that Muslim wife constant? Tell me, reply me this way. Reply me this question only.
One second. Let me first let's first respond to what Captain Singh has called us about. Shamina Shafiq, I believe the question was specifically to you. Do you want to respond to him, please?
Yes, I would like to respond to it. My all sympathies to you, gentlemen, but at the same time, please understand your case is absolutely different to the case that, or rather the subject that we are discussing and debating here. Here, I am talking about two individuals who want to have their lives apart despite of being in a marriage, which is absolutely fine if they don't want to live together. My only concern is that as per Ms. Luthra, even if the 5 to 7% people who take back their applications and they after the first motion and they get back together, why are we leaving them so vulnerable, and why are we not looking into the possibility that those 5 to 7% families can actually come back together after the first motion? My only concern is this.
So that
the other thing is,
open.
I'm not saying that only women are at the receiving end. It's also sometimes the men who are at the receiving end. I completely agree, and this is why I'm saying it is very, very important to have a cooling period, because if at all two individuals have decided to find their ways apart, so far so good, but there has to be some time for them to
Shamina,
think about.
If I've not misunderstood you, your argument, Shamina, your argument is that if there are 5 to 10% of the people.
And as far as triple talaq is concerned, can I talk about triple talaq?
Sure, go ahead.
Yeah, the triple talaq judgment that Honorable Court gave was a wonderful judgment, but unfortunately what the judgment speaks and what happens on the ground are two different stories. I can give you an example where right after 2 days after the judgment, a man divorced woman in one go and the woman did not know what to do. So it has to come from the society as well. As far as now the kind of divorce cases, the rampant divorce cases that we are seeing, especially in the bigger cities, and it's going to increase now further in the smaller cities. What my concern is, because there the women are not so empowered to understand what their rights are, and mostly it's going to be manipulated. The man will get freedom from the wife in one go. She will be forced, her family is going to be forced under various political, apolitical or whatever kind of pressures are there, and they will be sometimes, I'm not generalizing again, but then women are going to be forced to file for the first motion and get rid and the man will get rid of the woman. My concern is not about
if your argument is
can this judgment is not going to open a window for the Muslim community ki they will claim in future ki they want to.
No, I don't want to get derailed by religion. Please, let's focus on the conversation that we're having. This is not a Hindu-Muslim thing. We're talking about divorces.
Triple talaq,
let's focus on the topic.
Triple talaq, Faye, triple talaq is a relic. Triple talaq is not there in India now. If somebody wants to divorce by the way of instant triple talaq by mutual consent, at the lower level it's a different thing. But if the aggrieved party approaches a court, then it will be invalid.
Yes.
At the lower, like the lady rightly pointed out, at the lower strata, if it does not come to the
let's not get derailed by triple talaq.
Nobody can help
The Supreme Court has given us its verdict on triple talaq. That's behind us. Talking about it is a waste of time. I want to bring in a different angle here. Right. I want to bring in a different angle here, and I have Dr. Sidwani on the phone line with me, who's a psychologist. Now, we keep saying it's an extra 6 months. Remember, the court has said the waiting period will only prolong agony. It's important to understand the agony here, the mental agony that happens when a couple wants to go their separate ways.
I agree with him.
But they're required to stay married for the extra 6 months. Dr. Sidwani, if you can hear me, what is this agony as a psychologist that the Supreme Court is referring to?
Faye, I completely agree with Mrs. Mirani Deshmukh. We are all individuals. We have our individuality. Also, by court, it is a mandatory counsel has been given by the government that individuals have to go through counseling before they file and through the process of divorce. I think there's a lot of trauma and pressure because divorce is still a taboo in our country. So there's a lot of stigma still available where the divorce topic is concerned. A lot of females go through depression. A lot of people go through anxiety attacks. Children go through depression in this process of being shuffled between two parents and in the process of fighting in these 6 months. So I think we need to understand that as an individual, if somebody has taken the decision to file for divorce and to continue with their life forward, I think we need to respect it as a society as this is mutually done.
Right. I just want to understand. I want to understand from you when we talk about the agony. Do you believe that as a psychologist, shortening this 6-month wait period will spare people agony?
I think so, because I think if they have undergone a sufficient amount of counseling, they have taken the call, they have spoken together, they respect each other's decision. Of course, there's always going to be pressure from the family, from the friends, from their children.
It doesn't happen always. It doesn't happen always.
Right. It may not happen, but in most cases you see that, there is a confusion which sort of eases off in some time. I think 6 months is a very, very long time, and each individual is going through its own stressors in those 6 months. Which further, you have to see that, we have so many marital couples who come, and if you speak to them, most of them are undergoing depression. It's also the period that prolongs the depression.
Right. So we have a psychologist who agrees that the agony that the court refers to is a very real thing. I'm going to take this question back to Geeta Luthra, because I understand Geeta Luthra has to leave in a minute or so. Ms. Luthra, if we come back to women's rights, and this is fundamentally the conversation that's being had, which is that if the consent has been manipulated, won't the additional 6 months give a woman or a man who's being manipulated at this time more opportunities to speak to the court or to be able to find their rights?
So the manipulation which I was talking of is the manipulation after the first motion and the 6 months period during which people use to try to extract greater rights or to affect the person who has changed their position to adversely in order to go through the mutual consent. So this is the manipulation that I was speaking of. Now there is another manipulation which happens at mutual consent. The wife is not in a financial position that she needs a quick solution. She can't litigate long. Now at that level, a husband or a wife may manipulate the other to get a quick settlement. The wife may file a false case and add in charges which are incorrect. That manipulation, this judgment will not take care of and is not dealing with. The only manipulation that this judgment is dealing with is the one which happens in some cases where after doing a first motion with eyes open, a party tries to resile in the second motion, and also the agony which that they go through. So these two aspects, it's not saying that the 6 months goes. It is only saying that if both parties are agreeable, then they can shorten that 6 months to 7 days or 10 days, and the court will also examine it and can reduce it maybe from 6 months to 4 months. Maybe one party wants to get remarried and wants it at 4 months. Maybe one has a child who has to go abroad and they want to put a closure before that. So there are many reasons why someone may want a closure before 6 months, and the court can then have a free play to apply its mind and its discretion to ameliorate a pain if it needs to. So it's just giving the court the power if both parties are agreeable, and if the court in its discretion, after applying its mind, finds that it is something which needs to be condoned and treated as not being mandatory. That's all.
Right. Mrinalini Deshmukh, how often does the court turn around and say, yes, I agree with you, but I'm bound by law? You have to wait 6 months.
Many times, especially when all the terms have been complied with. And sometimes we do make an application, let me be very honest, and we tell the court that could you kindly waive the 6 month period. They would say off the record that we do agree with what you are saying, but ultimately our hands are tied, because this is what section 13B clause 2 says, that 6 months is a minimum waiting period, and you still have time till the 18 months period expire when you can do this. So today I think it is also easing the burden on the courts. If the courts are satisfied that there are genuine cases where the parties really want to wrap it up earlier, all the compliance has been done, and they voluntarily want to get out, and you know, as Geeta rightly stated, people have to go abroad, some people have to get remarried. There are various issues which are there. Do not keep them tied and in a painful journey which they've already gone through only because some sections have been added, and that's all that the courts are saying.
And that's all the courts. Let me just bring in Brinda Adige. Brinda Adige was nodding at the fact that, you know, there are a lot of cases when people have mutually agreed and they just want the courts to allow them to go their separate ways.
Absolutely. Because again and again we are talking of the mutual consent, which means there is a lot of thought that has gone into reaching this particular position of divorce. Divorces are not happy situations and incidents. There is a lot of pain, there's a lot of trauma, there's probably anger, but with all of it, we know that our court procedures are cumbersome, are tedious, and if this cooling period has been ruled out, well and good, because it is a situation that is comfortable now, both whether it is the man or it is the woman. What we are talking about is that any point of time the court still gives you that space, gives you that berth to say you can come back and ask for more time. But the courts need not hold this, saying that because of a particular clause, we are not able to now grant you that divorce that you have mutually come forward to. Reconciliation, compromises, counseling, mediation, none of this has worked, and you still want to go ahead with the mutual consent divorce, then this particular clause need not hold that case back. And we know, even though the person pointed out saying that there are so many, 70% or so that are pulled out, my question was again, how many of that 70% of your data were mutual consent that were pulled out or said that they do not want divorce? Now that number is very small, and that is why this is a welcome progressive ruling.
Absolutely. So the person who made that statement is Ajay Gautam. Ajay Gautam, you said, of course, that this is not a contract, that this is an oath. And my question to you is very simple. If that's true, that stands against divorce in general, and then the 6 month period makes no difference to breaking that oath, does it?
I'm talking about the divorce petition, and when you file a divorce petition, there is some clause that this is a mutual consent or this is a petition filed by the one of the party against second one. And my only concern is that in our Hindu society, how can we save this marriage institution? Because everybody take it, the divorce is a stigma on the society. Because the parents, due to their differences, they will got divorced, they will be reunion with someone, they will be remarried. But the main consider and core issue about the children. The children suffer a lot after the divorce, and as a responsible person of the society, we always do the consultation, and we also try to resolve the issues the parties have, and either when matter referred to the mediation, when the matter it's come for the chamber hearing, the judge also plays the same roles. They try their petition may be withdrawn and they will be reunion. When there is no option left, then judge allowed them for the divorce. So I am taking this is a oath, but how many petitions filed out of the if you see the number of the petition filed in the Hindu community is only 4 to 5%. And 90 to 95% people are happy with their lives, and you are talking about the 5% people who are filing their divorce petition, and with the person who are filing mutual divorce petition
rate is very high,
less than 1%. So why we are making this way very faster, we have to extend the cooling period so that the possibilities of the save this institution and reunion of the parties it may alive.
Sir, I have a question to you.
Just do away.
Yes. A couple has come, mutual consent. You are talking about the children. Let us assume that this is domestic violence. Let us assume that there is no love. Let us also look at that these two people have come there. Can you imagine the trauma, the pain that children are actually going through in this particular family then? What are we talking about upholding?
Ma'am, what kind of allegations they made in their petition? Have you read?
This child.
Have you read ever the nature of the allegations when they filed the petition of divorce? Then what kind of the nature of allegation? Have you read those petitions? My question is that, ma'am, have you read those petitions and the nature of allegation when they made against each other when they're filing divorce petition?
No, but you do understand, Ajay Gautam, that when we talk about a mutual consent divorce, there are no allegations. A mutual consent divorce application normally just says, listen, we have decided that we're incompatible and we can no longer live together. So in our, full realization of that and being separate for the last 1 year, we now decide to go our separate ways. In fact, correct me if I'm wrong, Minali, a mutual consent divorce application is the most politely written application
Absolutely.
ever.
And it does not wash the dirty laundry in public. It only talks about irreconcilable differences and incompatibility. And it also says a mandatory clause that we've tried to work on our differences. Friends and families and professionals have helped us to resolve it. But at the end of the day, we were not able to resolve. Hence, we humbly pray to the court that kindly give us this relief and give us. Now, when there's such a very polite way without having any allegation, an amendment in 1976 was made after 55 codification. The first codification of the law was in 1955. After that, in 1976, something was made. This is a progressive, constructive step towards the way the society is moving. And please, we all believe in the institution of marriage. But then even the legislation believes in that there could be situations when divorces happen. And can we then have an option to do it in a graceful and an amicable manner?
Lawyer. With respect, I'm asking you a question. You also aware about this fact before the filing the mutual divorce petition, what kind of exercise they have taken the place before that? They also have threatened the section 498A. If you are not filed the mutual divorce petition, we will file a case against you under section so and so. And the party who is not agree with the mutual consent, the party does not left any other option apart to sign the petition of the mutual consent.
So there is no mutual consent, that means, and the courts will
that is also applicable to 1 year cooling period.
That is
also applicable to 1 year cooling period. How does it change the situation?
This aspect also should be considered.
Okay, your argument then that the consent has been manipulated.
Even if you extend the cooling period, the same...
Yes, the cooling period doesn't change that in any way. If the consent is being manipulated...
Even if the cooling period...
Yes, Shayar Khan, go ahead.
It doesn't change, yes. Even if the cooling period is extended, how does it change the situation? Anybody who wants to coerce and intimidate will, on the basis of 498 will anyways do it.
Even if you include
and about the gentleman talking about children's, about the children's safety, you see, the problem is in a broken and dysfunctional marriage, children suffer more. Yes. Like the lady rightly pointed out, in a broken marriage, the trauma is more. So it is better to end the misery and get on, get on with your lives.
There's so many things,
like you said, Faye, mutual consent is the most polite and the kindest way of separating.
Right, I've run out of time. I've run out of time here, but just to recap for our viewers what has happened, the Supreme Court has decided specifically to do with the Hindu Marriage Act, but our legal experts tell us that this can now be referred to and applied to the Special Marriage Act and other acts as well. But basically, if it's a mutual consent divorce application where the couple have decided that there are differences that cannot be, worked through and they want to go their separate ways, they've already been separated for a year, they have sorted out all of the alimony and the child support and things like that and custody, they can approach the courts to consider waiving off the extra 6-month waiting period that the court, up till now, the law mandated. This would basically mean that people could get divorces faster if they met a certain list of criteria put down by the court. This is good news for those people specifically in this position who can now move on with their lives. And according to this order, it means that you can reapply or you can relook at this if you're waiting for that 6-month period to expire. The panel is split on whether or not it's a good thing, but simply from the point of view of rights of women, simply from the point of view of the law that moves with the times and understands society as it evolves, and simply from the point of view of our law being a living, breathing thing that needs to change with times, this is a step in the right direction. We thank the Supreme Court one more time for understanding what the citizens of this country truly need. Thanks for watching.